employment law, of course, encompasses the subject of wage and hour. And the first topic in that category would be the minimum wage. In New Jersey's current minimum wage is $7.25 an hour. There are some exceptions that do apply to the New Jersey minimum wage requirements, but an employer must also comply with federal minimum wage, which is also $7.25 an hour. And if an employer pays an employee minimum wage, that employer has to pay the employee in accordance with the minimum wage law, either federal or state, but whichever one is higher, that's the rate at which the employer must pay its employees. Next subject matter would be overtime. In New Jersey, there's a requirement that an employer pay overtime to its employees unless exempt. And they have to pay at a rate of 1.5 times the employee's regular rate of pay for all hours worked in excess of a 40-hour work week. There are many exceptions, and the Fair Labor Standard Act, as well as the state statutory framework, provides in both authority and governance over what those exceptions are. Then the next subject matter would be meals and breaks. New Jersey employers must provide employees under the age of 18 with a 30-minute break after 5 consecutive hours of work. You can find that law set forth in the New Jersey statute 34:221.17d, subsection Q4. New Jersey does not require employers to provide breaks, including lunch breaks, for workers 18 years of age or older. An employer who chooses to provide employees with a break in excess of 20 minutes does not have to pay wages for lunch periods or other breaks if the employee is free to leave the work site. In fact, if they take their lunch or their break and the employee does not actually perform any work, then the employer does not have to pay that employee for that time. According to federal law, breaks 20 minutes or shorter typically must be paid. The next area under wage and hour is vacation. In New Jersey, employers are not required to provide employees with vacation benefits, either paid or unpaid. If an employer chooses to provide these benefits, it is only required to comply with its established policy or employment contract. Neither New Jersey's legislature nor its courts have given any significant guidance regarding other potential vacation policy issues. They are silent regarding whether an employer may, for instance, establish a policy or enter into contract denying employees payment for accrued vacation leave upon separation from employment, or deny payment for accrued vacation to an employee upon separation from employment if its policy or contract is silent on the matter, nor require an employee to comply with specific requirements to qualify for payment of vacation leave upon separation from employment, such as giving 2 weeks' notice of being employed as of a specific date of the year. And then finally, again, silent as to a cap on a vacation leave or the vacation leave an employee may accrue over time. And then there is virtually no guidance on implementing a use it or lose it policy, requiring employees to either use their leave by a set date or lose it. Although New Jersey authorities are silent regarding many of the vacation policy issues, based on the contractual emphasis New Jersey has on vacation policies, an employer is likely free to implement the vacation policy of its choosing. An employer would be required to comply with the terms, however, of its policy or contract under basic contract principles. And Then the subject matter of sick leave is also governed under the wage and hour laws. However, in New Jersey, an employer is not required to provide its employees with sick leave benefits, either paid or unpaid. But if an employer again chooses, voluntarily chooses to provide sick leave benefits, it must comply with the terms of its established policy or employment contract. An employer in New Jersey may be required to provide an employee unpaid sick leave, however, in accordance with New Jersey's Family Medical Leave Act or under the Federal Family and Medical Leave Act or some other federal laws. An employee may also be entitled to benefits under New Jersey's Family Leave Insurance Program, which is funded by employee payroll deductions. So just generally, sick pay in New Jersey will be governed by general principles of contract. And then with respect to severance pay, it should be noted that New Jersey law does not require employers to provide employees with severance pay. Oftentimes I'm asked to review severance packages, and the employee requests how they can better their severance package. Well, the unfortunate news that I am required to deliver is that the employer is not required to have provided that employee with the severance package to begin with. Many times employers provide such packages just in order to avoid litigation, whether it's has merit or not. But severance packages are often accompanied by release agreements. That is, the employer will provide a severance package, a monetary benefit to the employee who will be separated from employment in exchange for the employee signing a release of its rights or any rights that he or she has to file a lawsuit or a claim against the employer. Now, with regard to holidays, New Jersey law does not require an employer to provide employees with either paid or unpaid holiday leave. In New Jersey, an employer can require an employee to work on holidays. An employer does not have to pay an employee premium pay, such as 1.5 times their regular rate of pay if they work on holidays, unless such time worked would qualify the employee for overtime. If the employer does choose to provide either paid or unpaid holiday leave, it must comply with the terms, again, of its established contract or policy, again, governed by general contract principles. And then jury duty is often an issue, and an employer also not required to pay an employee any wages for time spent complying with jury summons or serving on a jury. An employer may not discharge or penalize an employee, however, if the employee does or is required to attend court for jury service. That would be an illegal act on the part of the employer if that employer chose to implement any adverse employment action against the employee. And what I've just provided to you is again a brief summary and a generalization of the wage and hour laws. And for more details, kindly contact our offices at Douglas Law Firm.